Final case for the day. It is also a mini oral argument on the application. You each have 15 minutes. Mr. Miller, you can try and reserve some of yours for rebuttal. And I will, with that, call the case. It's Marquardt versus Umashankar. And you may proceed, Mr. Miller.
Thank you, Your Honor. The actual basis for this application and all of the previous efforts at appellate review are not complicated at all. It's whether or not I complied purposefully or inadvertently with the statutory requirement of 2912B2, which says if no last known professional business or professional address can reasonably be ascertained, notice may be mailed to the health facility where the care that is the basis for the claim was rendered. Dr. Umashankar left the country while my client was still in the hospital. He spent 6 months at the University of Michigan Hospital before her discharge, and he left in September of that year and returned, we learned later, to the United Kingdom and then to India. Now this is when the notice of intent was originally drafted in 2009. The World Wide Web or internet was not like it is now, and certainly doesn't contain the information that's on that net now. More importantly, as the court may or may not gather from all of the information that's been provided, there have been 3 appellate efforts to the Supreme Court. One was denied, which had to do with the Court of Claims filing. The other one was held in abeyance until the court had an opportunity to decide whatever, having to do with the last date of the statute of limitations, suitable to file a notice of intent. And so at that time, this court vacated the Court of Appeals decision in its entirety, which had addressed this issue favorably to defendant. When we went back to the trial court reasoned that they were still in a position to rule on this issue, and that's why we're here today. Still more importantly, the defendant has never asserted that he did not receive reasonable notice through the University of Michigan. In fact, the contrary is proven through the fact that the University of Michigan produced him for deposition, flew him back from India when the case was still pending in the Court of Claims, and never once asserted during that initial litigation that the notice had been deficient for him. And
Counsel, let me interrupt you and see what questions my colleagues have. Let's start with Justice Welch.
I don't have any questions.
Justice Zahra.
But at this time, thank you.
Justice Viviano.
So I'm a little confused by your last statement. Why would the doctor have objected to the notice in the first case if the notice wasn't of the fact that you intended to sue him?
Well, the notice said I intended to sue him.
Is that what you're?
It's true that the Court of Claims action was only against the University of Michigan. That is accurate. But then when that case was dismissed under failure to file a claim within the 60 days permitted by statute, a new notice of intent was sent to him. And that's, I think I've answered the question. You are correct that he was not a party in that litigation.
Am I correct that you didn't intend to file a claim against the doctor when you sent the initial notice out? That was.
Well, when I sent the initial notice, it specifically mentioned Dr. Umashankar's name, I think on 9 occasions in the notice, as the potential defendant, as well as a Dr. Haft, who was the cardiothoracic surgeon during the same procedure. So they were identified as the potential defendants in the original notice of intent. Then I made a decision to file the claim only against the University of Michigan in the Court of Claims. But I had not ruled them out as potential defendants when I sent the first notice of intent.
All right, thank you, counsel.
Justice Clement,
No questions, thank you.
Justice Cavanagh. You have additional time. You may use it or reserve some. Up to you, Mr. Miller.
Again, I would just emphasize the fact that at no time during any of the 13 or 15 briefs filed in this matter has there been a claim that the doctor did not receive reasonable notice, and I'll reserve the balance.
Thank you. Ms. Swanson, you may proceed.
Good afternoon, Your Honors. Joanne G. Swanson, appearing on behalf of Dr. Umashankar. In answer to the question that you posed in the MOAA order, the MOA order, the answer is yes. Under the precedent provided by this court in Driver and Potter and by the Court of Appeals in Fournier and Griesbach, as well as under the plain language of the statute, Ms. Marquardt failed to give Dr. Umashankar the notice required by MCL 600-2912. In Driver, this court held that an NOI sent to a physician is not notice to his professional corporation. In Potter, this court held that notice sent to a professional corporation that it was alleged to be vicariously liable for a physician was not given when notice was given to the physician. In Griesbach, this court held that an NOI sent to 2 defendants did not give notice to a 3rd defendant. And in Fournier, the Court of Appeals held that 5 different defendants, or notices intended for 5 different defendants, but inadvertently mailed to 1 defendant, did not provide notice to the other defendants. This rule that an NOI must be given to each defendant does not change when a plaintiff uses the alternative mailing rule. Notice must still be given to the intended recipient. And this is not only part of the case law that I've just recited to you, but it's also plain from the language of the statute, because subsection 2 expressly refers to the notice of intent required by subsection 1. And subsection 1 says that a person shall not commence an action for medical malpractice unless the person that is intending to sue has given the health professional or facility written notice as required by the statute. So by incorporating section 1, the alternative mailing rule still requires an intended recipient. And that is all that addressed or directed is intended to signify. Mr. Marquardt has repeatedly indicated throughout the pleadings in this case, and that is 3 Court of Appeals, three journeys to the Court of Appeals and 3 to this court. He has admitted that he did not send an NOI to Dr. Umashankar, and that should end the inquiry. But even if you go beyond that, even if the NOI had been addressed to Dr. Umashankar, the alternate mailing provision can only be invoked if the address of the intended recipient was not ascertainable by reasonable efforts. And it is undisputed that there was no effort to ascertain Dr. Umashankar's address because there was no intent to sue Dr. Umashankar at the time. Mr. Miller has just told us that he contemplated suit against the Dr. Umashankar and Dr. Half when he drafted the NOI. However, he admits on the first page of his supplemental brief that prior to drafting the subject notice of intent, the undersigned decided that Ms. Marquardt's claim would be filed in the Court of Claims with the UMHS as the only defendant. And then he states again on page 2, once the undersigned decided to proceed solely against UMHS in the Court of Claims, a notice of intent was prepared. The notice of intent was addressed to the risk manager at the UMHS, and the notice of intent was mailed to the risk manager. It wasn't mailed to Dr. Umashankar in care of the risk manager. It very plainly, and through their own admission, it was mailed to the risk manager. So the July 2009 NOI was not addressed to Dr. Umashankar. It was not sent to him for the very strategic reason that plaintiff did not intend to sue Dr. Umashankar when the notice period expired. And consequently, there was no attempt made to ascertain his address.
Counsel, I'll interrupt you and see what questions folks have. I'll start with Justice Welch.
Thank you so much, counsel. I'm wondering what your thoughts are on what kind of notice is appropriate. Is it always an individual notice to each individual doctor? Can multiple individuals be listed on a notice? I'm just curious what your thoughts are on that.
You could list, and I have seen numerous notices of intent that list multiple defendants, intended defendants, in the salutation and in the address section of the notice. But you can't just send that notice to one defendant. All of the defendants have to be mailed notice. That is required by the statute, and the express language of the statute, and it is also required by the case law of this court and the case law of the Court of Appeals, and it doesn't change simply because the alternate mailing rule is being used.
Right, thank you.
Justice Zahra?
No questions, thank you.
Justice Viviano?
No questions. Thank you, counsel.
Justice Clement?
No questions.
Justice Cavanagh?
I have just a short question, and maybe you covered this, but maybe you could explain it to me. I am not clear as to why it really matters whether or not plaintiff intended to sue Dr. Umashankar. The intent to sue him or not, the question is whether or not the notice was sufficient. If it was, it was. If it wasn't, it wasn't. What is the relevance of his intent to sue him?
I think it has, there are 2 points that make it relevant in this particular case. First of all, it illuminates the reason why the notice wasn't sent to Dr. Umashankar, as well as why it wasn't addressed to him. There was no intent to sue him, so there was no need to send an NOI. So this is all an after-the-fact attempt to retrofit a notice of intent that was admittedly intended for UMHS and apply that to Dr. Umashankar. And, you know, number one, it really emphasizes and underscores the reason why the statute wasn't complied with. But number two, I think it also shows us and illuminates the fact that this is not a proper case for this court to make any jurisprudential pronouncement on what this statute means, because it's all an after-the-fact attempt to retrofit it. When you're making a decision, if there is a decision to be made, which my opinion is that the statute is clear and the case law is clear, and all we need to do is to apply the law as we already understand it to be. But if there was some issue that this court had to decide, you wouldn't it would seem that you would not want to decide it on facts like this, where Mr. Miller has admitted that he didn't really even intend to invoke the alternate mailing rule. When we were in the Court of Appeals, Mr. Miller was very frank about it, and he indicated, and you can listen to this yourself, the MP3 tape of video, or it's not video, it's audio, is on the court's docket. He said something to the effect, I freely admit that when I sent the notice to University of Michigan, it was not my intention that this was an alternative mailing if I could not locate his last known address. So
Your contention then that the particular facts of this case or the particular intent somehow informs how we are to interpret the statutory language? I mean, if we were to conclude that it fits either, you know, the first part or the second part based on just the language, does it matter whether or not that was his intent?
well,
I mean, because the flip would be true, right? Even if he had intended to do it, but he hadn't complied with the statute, his intent wouldn't be relevant to whether or not the notice was sufficient.
I mean, you need to go by whether the facts show compliance with the statute. And Mr. Miller has already admitted that he did not send an NOI to Dr. Umashankar, which means there can be no proof of mailing of an NOI to Dr. Umashankar, and a proof of mailing under the statute is prima facie evidence of compliance with the statute. And the reason for that is because the proof of mailing shows the date after which notice tolling begins. But, you know, I understand exactly what you're saying about intent, and perhaps with respect to, if you're looking simply at the language of the statute and what the law should be, but this court always articulates a rule of law within the factual context of a particular case. And if you articulate a rule of law in this case that is based upon the after-fact creation or attempt to create facts that, you know, really are inauthentic, I think that really is not a proper basis for a jurisprudential ruling on what our law is going to be going forward. I think, you know, and I would guess that when you are deciding which cases to accept and what issues to decide, you look at the context, the factual context of the case in which those issues are presented to you, because I think you know and you understand how important that factual context is, and how lawyers will later look at that case and try to apply the law that you articulate based upon the facts of that case. And this does not provide that type of case, not when you have so much in the record that there was no intent to sue Dr. Umashankar, that there was no sending of an NOI to Dr. Umashankar. Basically, what is being asked of you today is to disregard the plain language of the statute, to apply an actual notice rule rather than a statutory notice rule. And this court has already said in McCahan and Atkins and other cases with which I know you are familiar, that it doesn't matter if there was actual prejudice. It doesn't matter if the recipient, intended recipient of notice, learned about it some other way. What is important is compliance with the language of the statute. And if that doesn't happen, the notice is not proper. But that's exactly what you're being asked to do. You're being asked to overlook the language of the statute and to help this plaintiff. And I understand, you know, I really understand Mr. Miller's plight here. But, you know, after three trips to the Court of Appeals and now our third trip to the Supreme Court, it's almost not fair to my client to try to contrive an issue on inauthentic facts. I mean, this has been a huge, as Mr. Miller frequently says, it's been 12 years, I think, since this case began.
Okay, thank you.
You have 2 additional minutes, counsel. You may use them if you like.
Yes, Your Honor. Justices,
No, sorry, Mr. Mayor. I
Just 1 second.
Ms. Swanson still has
I'm
to.
sorry.
I'm just going to briefly touch upon an issue you did not address, but it's an important issue. If you're going to get past the NOI issue, whether an NOI was properly sent to Dr. Umashankar, then you need to decide, does that really make any difference at all? Because Mr. Miller, although he didn't put this in his supplemental brief, his only theory can be that the NOI sent to Dr. Umashankar, quote unquote sent, extends the statute of limitations. And that is not the purpose of an NOI. An NOI has a very limited purpose. Or the NOI tolling has a limited purpose. It tolls the statute of limitations if during that notice period, a claim would expire. And that is its only purpose. It doesn't have the effect of extending the statute of limitations for all purposes forever. And for that reason as well, I think that this is not really a proper case for you to make a decision, because the end result has to be, unless you're going to deviate from the language of the notice tolling statute, the end result has to be, it doesn't make any difference anyway, because this is not what notice tolling does. It doesn't extend the statute of limitations. It has a limited purpose. And in Waltz versus Weiss, this court has already determined that the notice tolling statute doesn't even apply to the wrongful death savings provision. So, to try to use the notice tolling provision to extend the statute of limitations to then come to bring the decedent's death within 30 days of expiration of the statute of limitations, it's a long, squirrely road that it just doesn't lead to the result that is being sought by the plaintiff.
Counsel, I hear you that there might be a whole lot of other reasons why the plaintiff should lose, but the only question we're deciding today is whether the notice was sufficient under the statute, which I heard you to say in response to Justice Cavanagh that maybe technically it was, but because of the gamesmanship, I'm just going to say it that way, we shouldn't use this case to say so. Did I hear you correctly? It sounded like that was your response to Justice Cavanagh.
No, if I expressed that was, I did not intend. What I said was intent may not be relevant when you're looking at the statute, but you still need to apply the language of the statute. And under any, my position is that under the plain language of the statute, as well as the case law, that there's no way that they can win on this, because admittedly, no NOI was sent to Dr. Umashankar. And number two, there was no effort, no attempt at all to reasonably ascertain his address. So we don't know. Mr. Miller has only said what he supposes he could have found, but there has never been any evidence, any even allegation that he made any attempt to reasonably ascertain Dr. Umashankar's address in 2009. So because he made no such attempt, the premise for applying the alternative mailing rule does not apply. So my position is no on both the fact that no notice was sent, as well as the fact that reasonable attempt to ascertain the address wasn't made. There has to be, a finding, in my view, that this was not proper notice to Dr. Umashankar.
Thank you, Counsel. Mr. Miller, you have some rebuttal time.
Just a few comments, Your Honor. First of all, as I pointed out, this court has already vacated an opinion that affirmed counsel's position. Number two is that counsel repeatedly uses terms like sent, it must be sent to, or addressed to Dr. Umashankar. No such words appear anywhere in the statute. It simply says if no current address can be ascertained, it is mailed to the facility where the negligence is claimed to have occurred. That's all that the statute says. And there is no question in this case that the notice was sent to the University of Michigan within the period provided by statute. And if the other clear facts in counsel, you will notice, did not say in arguments that Dr. Umashankar did not receive timely notice, just as she hasn't in any brief that's been filed in this matter over the years. He received notice. That's the purpose of the statute, to make sure that the potential defendant is named. As far as my inability to show that I could have ascertained his address in India or the UK is strange at best, because several years later, when I attempted to do it, and when I attempted to serve him with the complaint in Washtenaw County, it took me over a year to find out and confirm his address in India, even though he had given us that address during discovery in the Court of Claims action. And he evaded service. It costs, I think, $5,000 to get personal service on him in India by having to hire skip tracers and every other thing. It's all documented in my attachments. The statute does not say that the notice has to be addressed to the potential defendant in such situations. It simply says the notice can be mailed is the word, mailed to the facility where the negligence occurred, because they would be in the best position to pass that notice on to him, which is exactly what happened in this case. And again, there's been no explanation as to why the Court of Appeals affirmation of defendant's position, which was vacated by this court, should have any validity or even or any support for defendant's position. Thank you.
Thank you, Counsel. Are there any additional questions for Mr. Miller? I should have said at the start of the argument, I assume, Counsel, you are both aware Justice Bernstein is not on screen because he is not participating in this case. But I should have said that for all the fans out there watching the arguments. That's why Justice Bernstein is not on screen. He wanted me to make sure I made that clear. Thank you both very much. The case will be submitted. That concludes today's case call. We hope the next time we see everybody, you will be watching us in our courtroom. Thanks all.
Thank you.
Thank you, Your Honors.